David Rivkin, a partner at Baker Hostetler and co-chair of the firm's Appellate practice, who also represented the Obamacare plaintiffs. In addition to his distinguished litigation career, David has served in various capacities in the federal government, including as legal advisor to Vice President George H.W. Bush and Deputy Director of the Office of Policy Development at the Department of Justice. You no doubt know David best from the daily op-eds he publishes in the Wall Street Journal, and he also co-authored the lead article in this year's review, offering an assessment of the ruling that is much more dispassionate than I can muster.
I agree with Randy's second point. As to the first point, I don't know. If this was passed as a tax, so there would not have been a need for rewriting. The arguments about propositions that this is not an income tax, this is not an excise tax, this is indeed a classical direct tax imposing you because you exist. And I'm saying it having read and reread the tax portion of the opinion at least a dozen times, and that it has not been apportioned and indeed may be incapable of apportionment. If one brought a lawsuit with well-written briefs and good oral arguments in the right circuit, 5th or 11th, for example, we might have done okay. I agree, it wouldn't have been as easy as all that. But this is one of those exercises in futurology that's impossible to predict.
I'm Charlie Hymack. I'm a retired military. And I would like to talk about or ask a question concerning the what you just talked about, that's the tax. I feel that that the individuals or companies do not have to pay the tax. And the reason why I believe that is, at least as a layman reading the Constitution, and excuse me for lecturing, but the Congress is the only one that has the right to write legislation or modify legislation. The executive branch cannot do that. They can, the president can approve or veto legislation, suggest changes, and the judicial branch, according to the Constitution, is not authorized to write legislation. Therefore, since they changed the words from a penalty to a tax in the deliberation of the court, it has to go back to the Congress, and the Congress has to rewrite the legislation, and the president has to approve it. So if someone goes and takes you to court for not paying, you can turn around and say, this is the legislation that was written. I don't have to pay it because it's a penalty.
Well, the short answer is that the court did not say that we wrote the statute. The court, as Randy and I have mentioned several times, the court has said that they merely construed what Congress has written, and I would say that I would not want to defend a person against a collection action on the theory that it's not what Congress did, no matter how much we as lawyers may feel that indeed the court rewrote the statute to save it. If you look at it from a standpoint of sweep of history, what's depressing to me is that he did it and the court did it at the time where its maturity and institutional legitimacy is pretty well established. There are many other instances, and I'm not even going to talk about the New Deal and the switch in time, but if you look at the very dawn of our constitutional history, I would say that a certain other Chief Justice was under much greater pressure in Marbury versus Madison, and if you look at what he did relative to enunciating the right of judicial review while finding a jurisdictional reason not to give Mr. Marbury his commission was far more commendable. So this was the time to be bold. This was not the time to trim sails, courtesy of all of Chief Justice's predecessors. Briefly, there's one interesting vulnerability that has surfaced, would not be really mature as far as ripeness goes for a little while, but some folks have noticed that the way both the employer penalty provision and the subsidy provision is written, it's triggered if you fail as an employer, for example, to provide coverage that is among coverage that qualifies in a particular state-run exchange. And the same is true relative to your subsidies. Since a number of states, courtesy of the Medicaid decision that Professor Bloomstein was portion of a decision talking about, are going to opt out, and a bunch of states are not going to run their own exchanges. You have federally run exchanges. The argument is in all those states, all the employers can drop people and pay no penalty, and nobody would be able to get a subsidy, which they otherwise qualify. You'd need to wait until 2014 to do that. But this actually, as a statutory matter, there's no constitutional significance. As a statutory matter, is a very compelling argument. That's how it's written, because it's badly written. If this thing pans out, then the irony here would be that this statute that was meant to increase coverage is going to lead to tremendous decrease in coverage, because that's what's going to happen. So that's the next, not as exciting as the constitutional issues that three of us have been kicking around, but a very interesting litigation yet to come.